Dear friends, I have the pleasure in sharing my presentation on HUF and taxation. We make use of HUF as an entity and for tax planning without understanding how Hindu undivided family comes into existence, how it works. Many times a question is asked how to make an HUF or create it. This question in itself is wrong because as always HUF always exists and it is never created. An HUF may be with empty coffer. It may be another issue how to create wealth for the HUF or how to make capital of the HUF, but it is so as to say to make an HUF or to create an HUF is a wrong statement. So I will take you through about the concept of HUF and a few issues for taxation which has come recently, like whether HUF can make gift or not, whether HUF can receive gift or not. All these issues which has come up in the recent past, I shall be taking you through my presentation. The first and the foremost question in this discussion should arise: who is Hindu? The Supreme Court, in one of the celebrated judgment of Dr. M. Ismail Farooqi and others versus Union of India, said Hinduism is a way of life. My Gurudev Swami Chinmayananda said हीनम दुष्यति इति हिंदू, अर्थात जो हीनता को नष्ट करे वो हिंदू है. As we know that in respect of certain matters like marriages, succession, Hindu law is codified to some extent. In that the definition given for Hindu is Hindu by religion in any of its form or developments, including a Veerashaiv, a Lingayat or a follower of the Brahma Prarthana or Arya Samaj, who is Buddhist, Jain or Sikh by religion, who is not a Muslim, Christian, Parsi or Jew by religion. Another category of definition is one is Hindu by birth if both parents are Hindu. Secondly, if either of the parent is Hindu, then the parent who has brought up as a member of the tribe, community, group or family to which such parent belongs or belonged, if he is Hindu by custom, by the tribe community, then he will also be Hindu. The another thing is how he has been brought up. The next category is one who converts or reconverts to Hinduism is said to be Hindu. मैं आगे बढ़ूं उसके पहले हिंदू जीवन के कुछ आधारभूत तत्वों की मैं चर्चा करने चाहूँगा, क्योंकि उसमें से पारिवारिक भाव एक प्रमुख तत्व है. सबसे पहले आता है यज्ञमयी भाव. यज्ञमयी भाव अर्थात देने का भाव. जिस प्रकार हम यज्ञ में समिधा होम करते हैं, उसी प्रकार से समाज को देने का भाव यज्ञमयी भाव कहलाता है. ईशावास्योपनिषद का एक मंत्र है, ईशावास्यमिदं सर्वं यत्किंचित् जगत्याम जगत तेन त्यक्तेन भुंजीथा माँ गृधय कश्यस्विधनम. सबय भूमि गोपाल की, इस भाव को लेकर के यह यज्ञ भाव चलता है. यज्ञमयी भाव है, जो भी हमें मिलता है जीवन में वह हम प्रसाद बुद्धि से स्वीकार करें, यही इसकी मुख्य भाव है. अंतर्वाह पवित्रता. आज हम चक्कू और छुरी, चाकू और कांटे का प्रयोग तो हमने बढ़ा लिया. शारीरिक स्वच्छता की भी हम बात कर रहे हैं, नैपकिन और सैनिटाइजर का भी हम प्रयोग करने लगे. लेकिन हमारे मनीषी उससे भी कहीं आगे थे, जो अंतर्वाह पवित्रता की बात करते थे. बाहरी स्वच्छता जहाँ आवश्यक है, उसके साथ ही हमारे मन की पवित्रता भी आवश्यक है. वे कहते थे जैसा अन्न वैसा मन, और अथवा जैसा मन वैसा अन्न. इसका हमारे जीवन पर बहुत असर पड़ता है, यह उनकी मान्यता थी. तीसरा है पारिवारिक भाव. इसको मैं सबसे अंत में लूँगा. उसके बाद आता है धर्माधिष्ठित जीवन. हमारे हिंदुत्व का मूल आधार है कि हमारे किसी भी काम करने की कसौटी क्या होगी, तो वह कसौटी होगी हमारा धर्म. धर्म से अर्थात कोई कर्मकांड नहीं, कोई रूढ़िवादिता नहीं, बल्कि धर्म मतलब हमारा क्या कर्तव्य है. आजकल रामायण सीरियल हम सब देख रहे हैं. उसमें हमने देखा कि किस प्रकार मर्यादा पुरुषोत्तम भगवान राम ने अपने धर्म को निभाया. जब पिता ने वनवास जाने की आज्ञा दी तो सहर्ष उन्होंने उसको स्वीकार किया, क्योंकि एक पुत्र के नाते पिता के वचन की सिद्धि करनी थी. जब वन में गए, माता जानकी का अपहरण हुआ, तो पति धर्म को निभाते हुए उनकी खोज करी और उनको वापस लेकर के आए. और फिर जब राजगद्दी पर बैठे, राजधर्म का निर्वहन करते हुए प्रजा का लोक रंजन होना चाहिए, प्रजा को के कहने पर माता जानकी को पुनर्वनवास दे दिया। ऐसी हमारी सुदृढ़ परंपरा रही है कि हमारा जीवन धर्म पर आधारित हो। फिर आता है विविधता में एकता। सबसे सुंदर उदाहरण है हमारे देश के 4 सुदूर कोनों में हमारे धाम, उत्तर दक्षिण पूर्व पश्चिम, चारों स्थानों पर शंकराचार्य ने जो हमारे धाम स्थापित किए, वह भी एक ज्वलंत उदाहरण है। एक भोजन नहीं, एक पहनावा नहीं, इतने यातायात के जिस समय साधन नहीं थे, उस समय इन सबको एक सूत्र में पिरोया, अर्थात जो संस्कृति का जो सूत्र था उसने एक माला बनकर के इस हिंदुत्व की माला को पिरोया। संस्कृति सबकी एक चिरंतन, खून रगों में हिंदू है, विराट सागर समाज अपना, हम सब इसके बिंदु हैं। ये आधार रहा हिंदुत्व। बालक का स्वरूप राममानस में हम कहते हैं ईश्वर अंश जीव अविनाशी। ईश्वर जो है वो भगवान का अंश है। हमने ये नहीं कहा कि ईश्वर अलग है, आप अलग हैं। सबके अंदर ईश्वर व्याप्त है और उसके अंदर क्षमता है। एक बालक, छोटे से बालक के अंदर भी ईश्वर को पाने की, ईश्वर बन जाने की क्षमता है। यह था हमारा चिंतन, यह हमारे जीवन का एक आधारभूत तत्व है। अब मैं आता हूँ पारिवारिक भाव। चूंकि आज का हमारा विषय है हिंदू अविभक्त परिवार, वह भी इसी भाव की एक छोटी सी कड़ी है। मैं और मेरा परिवार से ऊपर उठ करके एक समाज हमारा परिवार बनता है, एक मोहल्ला हमारा परिवार बनता है, एक गांव हमारा परिवार बनता है। उसके परिवेश से जब बाहर निकलते हैं तो हम राष्ट्र को एक परिवार के रूप में देखते हैं, और आगे बढ़ते हैं तो हम वसुधैव कुटुंबकम तक जाते हैं। उस परिवार के अंदर केवल हमारा परिवार ही नहीं रहता, तो बल्कि हमारे आसपास रहने वाले हमारे जीव जंतु, तमाम लोग हमारे परिवार का अंग बन जाते हैं। हम जानते हैं पुराने समय में जब गांव से कोई दूसरे गांव जाता था, तो अगर उस गांव में उसके गांव की बेटी ब्याही होती थी तो वहां का जल भी ग्रहण नहीं करता था। यह था हमारा पारिवारिक भाव, जिसकी एक छोटी सी इकाई है हिंदू अविभक्त परिवार, जो आज का हमारा विषय है। मैं आज के विषय पर आऊं उसके पहले मैं एक छोटी सी क्लिप हमारे पूज्य गुरुदेव स्वामी चिन्मयानंद जी की आपको दिखाना चाहूँगा, जो उन्होंने हमारे इस पारिवारिक भाव को लेकर के, इस फैमिली सिस्टम के बारे में कही है।
In the East, India and China, to an extent Russia also, it is not the individual, the unit or the society, it is the family. Therefore, even today, the family tie is strong and not the individual arrogance. Here, if a brother is successful and his younger brother is in losses and suffering, the younger brother will not get 1 cent from the elder brother. The elder brother says, you try your best, it's your luck. In India it is not so. If one brother has got a job, all his brothers and other families are together eating from that one income. Therefore, even though they say that 27% is the unemployment, 30% is the unemployment, nothing happens there. Nobody starves. Why? If one fellow has got an income, one grandfather has got some pension coming, that will do. The whole family will eat. The family unit. These all the beauties of it are forgotten in the modern craze of selfishness, that each individual, I and my wife, we will live together. We don't care what happens to the whole world. And even that, I and my wife also, a sacrifice is necessary. That is also too much, and therefore I alone. My life is only in a stepney. I take it and throw it away whenever I want, and there was. Each individual has become selfish, and therefore there is no integrity of the community, of the society. And that integrity of the community is then created by some artificial political ideology or a nationalism which cannot bind you because blood is thicker than water. The feeling that we are all belonging to one family, there is a greater affinity between the members of the family but if there is so much of overdosage of selfishness have come into the individual, individuals shatter.
As we know that Hindu law is codified only for a limited purpose of marriages and succession, maybe for one or more two things. But then what is the source of Hindu law? From where the Hindu law gets depends on for anything. The first thing is Veda is the first source of dharma. Dharma, as we know, that Hindu law is basically dharma based, and for dharma, the first source is Vedas, and then Yajnavalkya says, Shruti Smriti Sadachare Swasya Cha Priyamatmane Samyak Sankalpa Jaya Kame Dharma Moolamidam Vismritam. The Vedas, the Smritis, good conduct or approved uses is what is agreeable to conscience, proceeding from good intention, are the source of law. Friends, I am revising my presentation on this slide, if you have heard my presentation earlier. Now the first and the foremost question is, what constitutes an HUF? It consists of all persons linearly descended from a common ancestor and includes their wives and unmarried daughters. A daughter ceases to be a member of her father's family on marriage and becomes a member of her husband's family. You must have noticed that I have strike off certain portion of this paragraph, but I have read it because the struck off portions are the law as it existed before 2005, when an amendment was brought in Hindu Succession Act. What was that amendment? Section 6 of the Hindu Succession Act 1956 as amended by Act of 2005. It reads, on and from the commencement of the Hindu Succession Amendment Act 2005, in a joint Hindu family governed by the Mitakshara law, the daughter of a coparcenar shall by birth become a coparcenar in her own right in the same manner as the son, have the same rights in the coparcenary property as she would have had if she had been a son. Be subject to the same liabilities in respect of the said coparcenary property as that of a son, and any reference to a Hindu Mitakshara coparcenar shall be deemed to include a reference to a daughter of a coparcenar. Hence, for this reason, I have struck off certain portions of my presentation and instead have highlighted the word daughters. Now the current position is, it consists of all persons linearly descendant from a common ancestor and includes their wives and daughters. A question is raised with reference to daughters. There are generally two questions. One is there any distinction between married and unmarried daughters? As earlier, unmarried daughters were only recognized as member of the father's family. What is the status of this amendment? After this amendment, irrespective of marital status of daughter continues to be coparcenar of her father's family. Daughter is daughter, whether married or unmarried, it makes no difference. Then the second question which arises, what happens to daughters who is born before 9/9/2005? Earlier, there were decisions also, and this was the general belief that if the father of the daughter was alive on 9/9/2005, she would become coparcenar of her father's HUF along with her father. But if her father has died before 9/9/2005, she will not be a coparcenar in her father in the HUF of which her father has been a coparcenar. But now, with the decision of Honorable Supreme Court in the case of Vinita Sharma versus Rakesh Sharma, the whole scenario has got changed. In para 29 of his order of 2018, the Honorable Supreme Court has given the answer to the reference as under. The provisions contained in substituted section 6 of the Hindu Succession Act 1956 confer a status of coparcenar on the daughter born before or after amendment in the same manner as son with same rights and liabilities. 2. The rights can be claimed by the daughter born earlier with effect from 9/9/2005 with savings as provided in section 6(1) as to the Disposition or alienation, partition or testamentary. Disposition which had taken place before 20th day of December 2004. Third, this is more important, since the right in coparcenary is by birth, it is not necessary. Again, I will emphasize, it is not necessary that father coparcenar should be living as on 9/9/2005. Fourth, the statutory fiction of partition created by proviso to Section 6 of the Hindu Succession Act 1956 as originally enacted did not bring about the actual partition or disruption of coparcenary. The fiction was only for the purpose of ascertaining share of deceased coparcenar when he was survived by a female heir of class 1 as specified in the schedule to the Act of 1956 or male relative of such female. The provisions of the substituted Section 6 are required to be given full effect. Notwithstanding that a preliminary decree has been passed, the daughters are to be given share in coparcenary equal to that of a son in pending proceedings for final decree or in appeal. In view of the rigor of provisions of explanation to Section 6(5) of the Act of 1956, a plea of oral partition cannot be accepted as the statutorily recognized mode of partition effected by a deed of partition duly registered under the provisions of the Registration Act 1908 or effected by a decree of a court. However, in exceptional cases where a plea of oral partition is supported by public documents and partition is finally evinced in the same manner as if it had been effected by a decree of a court, it may be accepted. A plea of partition based on oral evidence alone cannot be accepted and to be rejected outrightly. On the face of it, it appears to be a very, very harsh decision of the Honorable Supreme Court, because in some cases where father of daughter has died in 70s or 60s and the HUF is being carried on by her brothers, by virtue of this decision, all daughters or sisters of those brothers will become coparcenar in the HUF of which her father has been coparcenar. But on the other hand, if we take a case where there was an HUF consisting of a father, his son and his grandson and granddaughter, and unfortunately if son has died and the HUF remained with grandfather and his grandson, because the son has died before 2005, granddaughter would not have become coparcenar unless this decision has been there. With this decision, now in this HUF, grandfather and his granddaughter and grandson both will be now coparcenars. So for some it may be a harsh provision, for some it may be an equitable decision which will bring granddaughters at par with the grandsons in the Hindu undivided family. The second and the most important thing of an HUF is that it's a normal condition of a Hindu society. It is assumed that family is joined unless and until it is proved otherwise. And what does it mean it is joined? It is joined in food, estate and worship. So normally when a question is raised whether there can be multiple HUF, my answer will be generally there cannot be multiple HUFs. But in certain circumstances, multiple HUFs may come in existence. That aspect I will deal later on when I deal with partitions. Mere separation in food and worship does not operate as a separation. In the big families, there may be incidents when there may be separation in kitchens because of living at far places. This situation may arise because of some family bigger family. To maintain harmony in family, some situations may arise, but that does not mean that the family has separated or a disruption in family has come. There are certain issues which many times arises uh, as regards what constitutes a HUF. The first and the foremost question is when only male members were coparcener, whether an HUF may consist of only single male member as widows of deceased male members. Now we can read it as an HUF may consist of only single coparcener and widows of deceased coparcenars. So, but the answer is yes, there may be situations in which there is one male coparcener, one male Hindu, his wife and his unmarried daughter. Or there may be situation, there is a daughter and brother's wife only. But it will constitute an HUF. A male Hindu and the widow of his deceased brother. A male Hindu and his wife. The only thing is a lone member, a lone coparcener, a lone member cannot constitute an HUF. There has to be minimum 2 members to constitute an HUF. It may even consist of 2 female members. The situation may arise that there is no coparcener, but in that situation also it may continue to be an HUF, and the only requisite is there must be 2 members at all times. Then secondly, an unmarried male member does not by himself constitute a Hindu undivided family. This is coming from this rule. There has to be 2 members in a family. A bachelor cannot constitute an HUF in itself. There has to be 2 persons. Once he gets married, his family comes into existence, he can constitute an HUF. There may be a situation he might have got some property by will, which says that this property go to the HUF of that person, but if that person is not still married, till he gets married, that will be his individual property. The moment he gets married, he becomes 2, it will become his HUF property. The rule is that the joint family property does not cease to be such simply because of the temporary reduction of the coparcenary unit to a single individual. The character of the property remains the same. The property does not lose its character of Hindu undivided family property merely because it has been reduced to a single member, but for the time being it may be treated as an individual property so long as there is no other person to claim right in the property, but the moment there is another person, that will become a joint property. Friends, now I come to what is coparcenary. Coparcenary is a person who can claim partition of the Hindu undivided family. Coparcenary acquires by birth an interest in the joint or coparcenary property. In other words, he has got a fluctuating interest in the HUF property. When a child takes birth in the family, his share gets diluted, gets reduced, and when someone dies in the family, his share in the property increases. That's why it is called that coparcenary has a fluctuating interest in the property of the family. Second and the most important thing is it consists of 3 generations next to the holder in unbroken male descent. That is father, his son, grandson and great-grandson. These 3 generations will count as a coparcenary, and this I will deal with an example later on. But here at this point, as I have written male descent, now by amendment of section 6 of the Hindu Succession Act, daughters have also become coparcener in their own rights. As if they would have been a son, they would have become so. Now the daughters up to 3 generations from the holder will also become coparcener as per the new amended provisions of law. A question here arises is what happened to the descent of daughters? Whether son or daughter of a daughter will also become coparcener or not. Here there are divergent views. Debate is going on amongst professionals, but I am of the firm view that daughter's descent, daughter and son of daughter, will also become co-partner in the of the family in which their mother has become co-partner. In my view, coparcenary is a unit. When daughter becomes a co-partner of her father's family, she becomes co-partner as a unit. She does not have any independent individual existence, as his counterpart is her brother does not have any independent existence in the HUF. As her brother becomes as a unit up to his two two generations will also become co-partner in the family. Similarly, on the daughter's side also, in my view, her descent up to two generations should also become co-partner in her Nana's family, so as to say. But there is a divergent view. It will take some time to settle unless and until some matter reaches to the Supreme Court or the High Court and some decisions come. Another important aspect in the context of coparcenary is what is ancestral property, because this is one of the important limb of coparcenary property. Ancestral property is inherited from his father, father's father, father's father's father. In other words, maternal side, any property received from maternal side does not count as coparcenary property. It becomes a separate property of the recipient. Similarly, property inherited from others, collaterals, also does not become HUF property. It becomes his separate property. Proceeding further, ancestral property is a species of coparcenary property. As I said, when we will discuss whether what can constitute coparcenary property, the one of them is ancestral property. Second thing, it's a creature of law and cannot be created by act of party. As I said, coparcenary is a creature of law. One cannot become a coparcener of a family by an act of party. By birth, one becomes coparcenary if he is within the 4 degrees of descent, but one cannot introduce someone as a coparcener in the family. However, by adoption, if one joins a family as a son or a daughter, by adoption, he becomes a coparcener. Then a member of a joint family may be removed more than 4 degrees from a common ancestor, and yet he may become a coparcener if he is from the present holder within the 4 degrees, he can become a coparcener. The moot test for a coparcenary is whether he can demand a partition. If he cannot demand a partition, if he is only a right of maintenance, then he will not be a coparcener, he will only be a member simpliciter. This is the difference. If one can demand partition, he is a coparcener. If he cannot demand partition, he is not a coparcener, he is only a member of the family. The rule is that partition can be demanded by any member of a joint family who is not removed more than 4 degrees from the last holder, however remote he may be from the common ancestor or original holder of the property. So this is the moot question. We will explain with the diagram in a later slides. Here you see this diagram. Babulal is the grandfather, Shamlal and Shampati, their sons and his son and son's wife. Then further he has got one grandson, one married granddaughter and one unmarried daughter. They have also got, one son has got son, daughter and married daughter. Similarly, married daughter has got one son and one married daughter. And they have further has got son, daughter, etc. Here, this colored portion being in the fifth degree, they will not be copartner, they will only be male, they will only be member of the family. The 4 degree will be Babulal degree 1, Shamlal degree 2, grandsons and granddaughters degree 3, and then great grandson and great granddaughter degree 4. So this will be, whole will be become coparcenary. Only male members and the daughters, though female, but will become coparcenary. Here he has got no daughter, he has got grandson. Grandson, no doubt, being a male, is a coparcenar, his wife is a member. But here the question is whether his married daughter and unmarried daughter will become coparcenar or not. In my view, they will become coparcenar because they are daughter of Shyamlal, who is a coparcenar of this HUF. Section 6 as amended of the Hindu Succession Act says daughter of a coparcenar. It does not say daughter of a Kartha or daughter of the senior member of the family. So they are the daughters of coparcenar Shyamlal. So in my view, they will become coparcenar. As far as her husband is concerned, law does not say that he will also become member of this coparcenary. So leaving aside, we can give view that he will not become member, but daughter will become coparcenar, though she is a granddaughter with reference to first degree of the person. Similar is the case with the great granddaughter and great grandson. Here great granddaughter is also daughter of the coparcenar, whether married or unmarried. In my view, they will become coparcenar so long as they are within 4 degree of the last holder of the coparcenary. So in my view, with this diagram, last graded portion, colored portion, they will not be coparcenar, they will only be member of this coparcenary, and these 4 degree will be coparcenar. In this case, what I want to show is, see, between this in a train accident or in a plane accident, we can say that this family lost, died. Now the remaining in the family is Babulal and his great 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 child, son and his wife, son, daughter, son and daughter. So will they, whether these persons will be coparcenar or not, whether it will constitute an HUF or not, here in this case, since they are in the 5th degree from Babulal, son, daughter, they are in the 5th degree from Babulal, and in between there is no one to link them with that, they will not become coparcenar, they will continue to be simply member of this family, and this will become single coparcenary property. They will only have a right of maintenance and nothing more. It will become a single coparcenary HUF. What is coparcenary interest? As I said earlier, there is no fixed interest. It is fluctuating, increases with the death and decreases on birth. A child birth takes place in the family, the interest of each coparcenar gets reduced. If a death takes place in the family, the interest of each coparcenary gets increased. The rights of each coparcenar until a partition takes place consist in a common possession and common enjoyment of the coparcenary property. Unless a partition takes place, each partner has a right of common possession and common enjoyment. They cannot separately claim the property unless a partition is claimed. What are the incidences of coparcenary? One gets rights and property on birth, and ownership rights in the ancestral properties acquired on birth. Thereafter, at any time, he may work out their rights by asking for partition. Till partition, has ownership extending over the entire property conjointly with the rest. It implies that as an incidence of coparcenary, every coparcenar has a right, is a joint tenancy, rights over the property, and may enjoy common possession, common enjoyment, but one cannot say that this is property belonging to him exclusively unless and until his rights are determined by partition. By asking for partition only he can separate his rights and determine his rights. Going further, the possession and enjoyment of the properties is common. No alienation of property is possible unless it is for necessity without the concurrence of the coparcenar. Interest of a deceased member passes on his death to the surviving coparcenars. But now this is to be read subject to the provisions of Hindu Succession Act, which says that the interest of the deceased copartner will go either by testamentary succession or intestate succession as per Hindu Succession Act. So this decision is no more a valid law after the Hindu Succession Act. What constitutes an ancestral property? As I said earlier, inherited from paternal ancestor, maternal grandfather, not an ancestral property, inherited from collaterals, not an ancestral property, inherited from females, not an ancestral property, share allotted on partition, ancestral property, property obtained by a gift or will from paternal ancestor, here intention is to be gathered, accretions, ancestral property. But now after the Hindu Succession Act, one has to be very careful, because the property which is inherited, that is an individual property, not an ancestral property as per law, unless and until will specifies that this property shall go as a HUF property, as a property of the family. In Arunachal, Mudaliyar versus Murugantha, the Supreme Court, after a consideration of the text on the subject and the variant opinions of the High Court, took the view that the question was primarily one of the intention of the donor or the testator to be gathered from the terms of the deed of gift or will. So, unless and until there is a clear intention in the will or the gift that the property should go to the family, it will become an individual property. I will deal with later also. What are the rights of the members of a coparcenary? As I said earlier, a Hindu male or daughter and his or her lineal descendants up to and inclusive of his great grandsons constitute the coparcenary. Unity of ownership in the joint family property. There is a fluctuating interest. There is a provision and enjoyment is also joint. Female members except daughters, not the copartner, like son's wife, Kartha's wife, they are not copartners, they are only members of the family. Children of a copartner takes per capita. This aspect we will discuss later. So children of a copartner takes per capita. This question is often asked, who can be Kartha of the HUF? The general rule is a senior most male member, that is copartner, will become Kartha. But now, since the female daughters is also a copartner in the family, in my view, she can also be a Kartha. And the law and the general tradition is the senior most person becomes Kartha of the Hindu undivided family. The Supreme Court in CIT versus State Govindram Sugar Mill 57 ITR 510 held that only a copartner can be the Kartha or manager of a joint family. Since a widow or a mother is not a copartner, she cannot be the manager of a joint family. Since a widow cannot act as Kartha, any alienation by the widow of a copartner property is not permissible. This was by Odisha High Court in Kamla Kumari versus Hari Krishna. So we should always see that who is the Kartha of the HUF, because if she is not entitled to be Kartha, any action taken by him will be invalid action. Now, so far only senior most male member happens to be the Kartha, but now since daughters are also are also copartner in a family, eldest daughter or a person who is eldest in the family can also become Kartha in my view. There is another view that if all the copartner agree, a junior member can also be a Kartha. Junior, earlier it was a male member, but since daughters are now equal, in my view, a junior daughter may also become a Kartha if all the copartners agree, because there may be a situation the senior most member may be very old, may be infirm, may not be able to manage the affairs of the family, so the copartners may decide to designate any other junior person as a Kartha. If they all agree, a junior member can perform or can be a Kartha of the family. What are the rights of the Kartha of the family? Rights of the manager or Kartha is to manage the affairs of the family. and to alienate the family properties for legal necessities or for the benefit of the family to the extent necessary. Basically, these are the two duties or rights of the Karta: to manage the affairs of the family and to alienate the family properties. For what purpose? For legal necessities, for the benefit of the family to the extent it is necessary. If Karta is father of the family, then he has got some additional rights. What are those additional rights? He can separate some or all the members whether they desire it or not, but the allotments of share in property should be equitable. He can gift away a reasonable amount of coparcenary movable property to the wife, daughter or son out of affection. Here one should note that it is not immovable property, it is only movable property, and that too a reasonable amount. But since then he can gift away a reasonable portion of immovable property for religious or charitable purposes. Then he can dispose of the family property in order to discharge his antecedent debts. He may also dispose of the family property for discharge of the debts which are existing. One more question is asked whether one can renounce his share in the coparcenary property or relinquish it. He can, in favor of other coparcenars as a body, but he cannot say that I will give my share to this coparcenar and not to others. Coparcenars as a body he can relinquish. Suppose there are 4 brothers, one may say that I am relinquishing my right in the share of the family. He can do that, but he cannot say that I will give my share to such and such brother only. Partition is a severance of joint status, and as such it is a matter of individual volition. There should be an intimation, indication or representation of such intention, and that what form that manifestation should take would depend upon the circumstances of each case. Manusmriti says, Urdhvam pitrascha matuscha sametya bharataras samam bhajiran paitrakam riktham nishaste hi jivato. After the death of the father and of the mother, the brothers may divide among themselves in equal shares the paternal estate, for they have got no power over it while their parents are alive. This is about partition on the property with the father during the existence of father and mother. What is the subject matter of partition? Subject matter of partition is the coparcenary property and not the separate property. While doing partition, there are certain provisions required to be made. What are those provisions? One is joint family debts, personal debts of the father, as we just said, that he can pay antecedent debts out of the family property. So there need to be provision need to be made for personal debts of the father. Then maintenance of dependent female members and disqualified heirs, and marriage expenses of unmarried daughters. Now in my view, since daughters have got equal rights as that of son, this provision may not be required for making any provision for marriage expenses of unmarried daughters, because they will be getting share in the property on partition equal to their sons. Who are entitled to share on partition? Sons, grandsons and great-grandsons, daughters. It will also include granddaughters and great-granddaughters. As I said, they are becoming coparcenar as per amended provisions of law. The third category is most important: sons, daughters begotten at the time of partition but born after partition. Share will have to be made for them. Then wife, when there is a partition between the brothers and their father, the one share is kept for mother of the family. Wife means wife of the Kartha or mother of the coparcenars. They will be getting one share each. Each son or daughter takes a share equal to that of a father. Where it consists of brothers, each take equal share. Each branch takes per strips. Partitions, how affected? It can be orally, by giving notice to other coparcenars, by executing a deed of partition or by deed of release, or by serving notice on others by any coparcenar who is entitled to seek partition that I want that property to be partitioned. Partition may be full or partial. Partial as to property, partial as to persons. Let me explain. Suppose there are four properties in a family. Family may decide that we will divide one property, which is the ancestral property, will be in the joint possession. It will continue to be family property, and rest of the three properties will be partitioned and divided amongst the coparcenars. It may be partial as to persons, like there are four persons, four coparcenars. One of them may want to separate from the family, or two of them may separate from the family, and two may continue to be part of the remaining family. So in this way there may be partial or full partition. But as far as income tax is concerned, income tax disregards the partial partition, because as we know, we are very much in engineering the provisions of law. So by partial partition, a number of combinations and permutations became possible, and by one HUF one can create hundreds of HUFs. So to curb that practice, the institute brought provision that partial partition will not be regarded, and in case of partial partition it will be disregarded, and the main family will continue to be assessed as such. Having partitioned or separated from the family, can reunion take place? Now the question is, can the person who has separated or gone out of the family can come again and join the family? The answer is, there are divergent views. One view is, can take place only between persons who are party to the original partition. Then there are divergent views. According to Mitakshara, Dayabhag and the Smriti Chandrika, a member of a joint family, once separated, can reunite only with his father, brother or paternal uncle, but not with any other relation. As for instance, paternal grandfather or paternal uncle's son, though such relation was a party to the original partition. According to Vivek Chintamani Mithila School and the Mayuk, Bombay and Gujarat, a person may reunite with any relation who was a party to the original partition. So there are divergent views. One view says that one can reunite with those only who was the party to the original partition, and one view is only with the brothers and father he can reunite, but reunion is possible. No writing for reunion is necessary. Effect of reunion is to remit the reunited members to their former status as members of the G union, as a members of a joint Hindu family. Now coming to succession. Succession of a Hindu is governed by Hindu Succession Act 1956. It empowers a Hindu to dispose of by will or other testamentary disposition even interest in Hindu coparcenary property. Section 6 provides for devolvement of interest in coparcenary property by testamentary or interstate succession and not by survivorship as it earlier used to be. Now a question here comes, whether a property received from as a succession will amount to coparcenary property or separate individual property, as it is an ancestral property. As the Supreme Court held in CWT versus Chandar Sen, that it will amount to a separate individual property even if it is a ancestral property. But if it is by testamentary succession, then if it is provided in the will that it shall go to the family of the successor, it will become ancestral property and the family property. Now I come to specific issues of HUF which are raised in every day in our professional discussions. The first and the foremost question which is raised is, can a HUF be a partner? Section 11 of the Companies Act 1956 has provided that where a business is carried on by two or more joint families, in computing the number of persons for the purposes of subsection 1 and 2, minor members of such families shall be excluded. 1956 Companies Act of 1956 has recognized this factum that two families joins a partnership firm. Then we know section 40 subsection A, clause A and clause B, read with explanation 1 and 2 of Income Tax Act also talks of representative capacity. When a person is partner in a representative capacity, but the matter does not end here. In the Act of 2013 of Companies Act, there is no recognition of joint family partnership. Secondly, an HUF is not a legal entity. When HUF is not a legal entity, it does not have a contractual capacity. It cannot enter into any contract. And partnership, as we know, that is a contract is an agreement between persons who have agreed to share profits or loss of business. There is an agency relationship. But earlier, there used to be a partnership between Kartha or coparcenars with others representing their HUFs. Qua partnership, they were individual partners, but qua HUF, they were representatives of the HUFs. But now there is a decision of Supreme Court in the case of Rashik Lal and Company versus CIT Odisha, in which it was observed that when one person cannot directly become a partner, he cannot become a partner indirectly also. So in view of this judgment, now banks do not recognize any such representative capacity, and if a HUF becomes partner as through coparcenar or Kartha, it is not recognized by banks because of this judgment, and more because there is, in case of HUF, the ratio, the rights of the coparcenars or members are fluctuating. They increase or decrease. So to avoid such controversies, now the banks are not recognizing any partnership firm in which HUF is made partner through coparcenar or Kartha representing their HUF. Second question is, can HUF receive gifts and claim exemptions under section 56? We know that section 56 provides that if an individual or an HUF receives any amount in excess of rupees 50,000 from persons who are not exempted, it will be liable to be taxed under the head income from other sources. Now we know that from 1st October 2009, there is an exemption if an HUF receives something from its members. But if HUF receives gifts or receives anything from non-members, it will not be exempt because there is no such exemption provided in this Income Tax Act in explanation to section 56(2)(7), where certain definitions are given from whom the main exemption is from relative, and in relative definition, in relation to HUF, it is said that it will be only members thereof. The second question is, will gifts received from HUF to members will be exempt from tax? This may be divided in two categories. First is gifts from own HUF in which the recipient is Kartha or coparcenar. There is a decision of Gyanchand Vardia versus ITO reported in 93 taxman.com 144. We must read this judgment. I have my own views on this judgment. This judgment is a classic judgment in certain respects. Number one, the case was not pleaded properly in my view. When we say from the beginning that it is a gift from HUF, the moment we say that it's a gift from HUF, we fall in the clutches of section 56, and we will have to prove that it is an exempt gift as defined, as provided in section 56. That was the first mistake, I will say, was done by the pleaders in this case, by the advocates, by the advisors in this case, when they said that Kartha has received this gift from his HUF. they were relying on earlier judgment of the tribunal only, in which it was held that if an individual received gifts from his HUF, it will be exempt because HUF is a compendium of relatives, is a group of relatives. When gift is exempted from relative, it will also be exempt when it is received from group of individuals. That judgment has been referred to in this later judgment of Gyanchand Bardia, but not followed, saying that much water has flown after that judgment. That judgment is also pending before the High Court. And thirdly, when specific provision has been brought in now as regards HUF, receipt from their members making exempt, no such similar provision has been brought in respect of in relation to an individual for receipt from HUF, so this will not be an exempt gift. I will put it differently. Per se, when a coparcenar or a member receives from HUF, it is not a receipt of a gift, or it is not a receipt from money from someone else. A coparcenar or a coparcenar has always antecedent rights in the property, rights in the income of the HUF, and whatever he receives from the HUF or received from HUF, it is his right to receive, which he receives. There were antecedent rights which only get crystallized on receipt, and so in my view it does not amount to gift at all. And so if it should, but it was not pleaded at all, this view was not taken, and so we have this faulty decision. I hope over a period it will get rectified if properly argued. The second aspect, which is more important, when we play with the law, when we twist the law in our favor, then also such things happen. What has happened? What is the fact? And I will just like to quote to highlight why such things happen. But the appellant forgets the difference that the Kartha of the HUF manages the affairs of the HUF as trustee of the HUF and on behalf of other members. When the Honorable Parliament brought amendment to the statute declaring gift from member to HUF as tax-free, but it was not considered proper to make gift from HUF to member as tax-free, because if such provisions are made, the Kartha of HUF may misuse the provisions and gift the corpus of the HUF to himself, as other members of the HUF have no control over managing affairs of the HUF. Therefore, contention of the appellant is found legally not acceptable, hence it is rejected. So we should also go through the facts of the case. When I went through the facts, I found that in this case, amount of rupees not less than a crore, 1 crore 2 lakhs of rupees was received by Kartha, so-called as so-called gift from HUF. And who were the members of the HUF? He himself, his wife and son. Virtually he himself and his son, these two were the coparcenars in this HUF. So when we do such things, we deprive the rights of other coparcenars in the HUF. Not only the present coparcenars, but the future coparcenars or would-be sons and would-be daughters of the family, so-called, we also hamper their growth. Is it permissible? Can we make use of or make fun of this pious entity of HUF to the detriment of other members of the family? If we do so, we are bound to have such decisions, which is this, because when we go only by the letter, not by spirit, then certainly we are doing major harm to the society as large. So we should be very careful when we do such plannings, just to take advantage of such things. So let us see how this judgment of tribunal turn out to be at a later stage. But in my view, it is not a gift at all. Since beginning, it should have been pleaded that anything which is received by a Kartha or a coparcenar from HUF is not a gift at all. He is only receiving his own money, in which he was having antecedent rights, which gets crystallized. One more thing I will like to add here. What for HUF exists? हर परिवार में हम जानते हैं कुछ कुछ अपनी अपनी परंपराएं होती हैं, पद्धतियां होती हैं. हर परिवार के महिलाओं को, बच्चों को कुछ पॉकेट मनी दी जाती है। कुछ बच्चों को हो सकता है साल में घूमने के लिए भी पैसे दिए जाते हों। आज की तारीख में जब बच्चे पढ़ने के लिए बाहर गए हुए हैं तो स्वाभाविक रूप से उनके खर्चे के लिए, आजकल डिजिटल इकोनॉमी का ज़माना है, हम उनके अकाउंट में पैसे भी ट्रांसफ़र करते हैं जिससे कि वो अपने वहाँ खर्चे को मीट कर सकें, खर्चा कर सकें। तो क्या हम कहेंगे कि ये गिफ्ट है उनकी? ये तो उनका अधिकार था, उनका राइट था कि फैमिली उनको मेंटेन करे, उनको खर्चे के लिए उनको पैसा उपलब्ध कराए। लेकिन गड़बड़ तब होती है जब हम अपने किसी स्वार्थ के लिए किसी एक व्यक्ति के खाते में, किसी एक व्यक्ति की ओर हम जब रुझान कर देते हैं, तब गड़बड़ शुरू होती है। जब हम फैमिली की बात करते हैं तो हमें सबका ध्यान रखना चाहिए। सबके दृष्टि से जब हम काम करेंगे तो इस प्रकार की चीज़ें नहीं होंगी। जब हम लेटर की में स्प्लिट खो करके लेटर में बात करते हैं, तब इस प्रकार की बात भी, हम गिफ्ट और इस प्रकार के जब शब्दों का प्रयोग करते हैं तो हम उसकी मूल भावना से भटक जाते हैं और उसमें दिक्कत आती है। इसमें एक बात और भी हो सकती है कि हो सकता है कि घर में दो बच्चे हैं, एक बहुत खर्चीला है, बहुत ऐशो आराम से जिंदगी बसर करता है, एक अपने कम खर्चे में काम चलाता है। दोनों को अपने खर्चे के लिए समान राशि दी जाती है। एक हो सकता है उसमें से बचत कर ले जाता हो। तो क्या ये अपराध हो जाएगा? ये कहीं नहीं लिखा हुआ, ना कहीं हिंदू अविभक्त परिवार के सिस्टम में है कि सबको बराबर बराबर खर्चा करना ही है। एक अपनी पद्धति है, परंपराएं होती हैं, उसके हिसाब से परिवार चलता है। तो मेरे हिसाब से ये गिफ्ट कतई नहीं थी। अधिक से अधिक जो कहा जा सकता था डिपार्टमेंट की तरफ से भी कि ये पार्शियल पार्टीशन है, क्योंकि संपत्ति के ऊपर किसी एक ने अपना अधिकार जता लिया, यानी कि उसने उसके ऊपर अपना कंट्रोल कर लिया। टू द एक्सटेंट इट कैन बी सेड दैट इट्स ए पार्शियल पार्टीशन which need to be de-recognized, and whatever income will flow from this amount, that will continue to be taxed in the hands of the HUF. But in my view, it's not a gift, and so we should always take care whenever we give reply not to use the word gift. We should only say that whatever amount I have received from HUF, it was my right which I have received as a right. Section 10(2) also, because of this reason, makes exempt specific provision exempt for a income received from HUF. Then come to next, this question is also very much asked, can there be multiple HUFs? As I said earlier, there has to be joint in food and worship. A single person can be joint in food and worship in how many HUFs? I found one instance in which case a person has got 2-3 sons, but one HUF was made with father and with one son. In the remote area of our country, when I asked him what is the nature of this HUF, how this HUF came into existence, there was no reply. Just simply a return was filed, the PAN was taken in the name of HUF, some return was filed, and everyone was happy that no, this HUF has come into existence. But in my view, at any point of time it may create a problem. It can be only a joint property, it cannot take a shape of HUF. Yes, there may be instances when there is some link with the bigger HUF. As I discussed earlier, multiple HUFs is possible to come into existence qua property, I will say, not qua person. There were 3-4 businesses of HUF when partition took place. It was decided that all businesses will not be partitioned. One business will continue as it is with the bigger HUF. Other businesses will be divided or partitioned between different groups of coparcenars, and in that way this one bigger HUF may split into multiple HUFs. But directly to say that without any linkage with the bigger HUF, no multiple HUFs can come into existence, just by making permutation, combination, and just filing the income tax returns. One more thing, I'm just skipping. Then can HUF engage in speculative business? This is also a very, very important thing to know. Many times we took speculative profit or speculative relative losses in this HUFs. Then can HUF engage in speculative business? Then I will come in what type of business a HUF can engage itself. What is the principle? We all know the story of Valmiki, who was earlier a robber named Ratnakar. When Naradji came to him and asked him whether your family will contribute, will share your sins, he said yes, why not? Then thereafter he said, Naradji asked him to go and ask to his family. When he went to his family, nobody agreed to share with him in his sins. Similarly, an HUF cannot put at risk all other members by engaging him in the speculative business. There is there are two decisions, one of the Privy Council, as held by the Privy Council in Sannyasi Charan versus Krishnadhan, that the Kartha of joint family cannot impose upon a minor member of the family at risk, and liability of the new business is started by him and adult members. The Kartha cannot impose such risk and liability even on the adult members without their consent. Similar view was taken in the case of Banaras Bank Limited versus Harinarayan. So we have to be very careful when engaging in a business. A HUF cannot engage in speculative business, because in such a business we put on risk not only the existing members but also the future members or future co-partners' interest in the property. Minors cannot consent to any decision, but for adults also their consent will be needed to engage in speculative business. Then the question arises, in what type of business an HUF can engage itself? In my view, as we know that personal skill, any income which arises from personal skill, personal caliber amounts to individual income. Anything which has got linkage with the family property will give rise to the income of HUF. So, while deciding business, we must see that there are some things, certain linkage with the existing family property which is giving rise to the income of the HUF, so that there is no doubt that it is a business of the family or it is an individual business. The last issue is partial partition of HUF having income below taxable limit. What is partition? Full partition, as the Income Tax Act says, partition means by metes and bounds. So, in the meaning of income tax, partition has to be of all the parties, between all the co-partners and of all the properties with metes and bounds. It cannot be in a piecemeal manner, as I discussed, that some property will continue to be HUF property of, it may become joint property of two persons by assigning proper shares, but it will not continue to be HUF property of those two brothers. So now the question arises, so far the HUF was not having income. It was having a property, but the income of the HUF was below taxable limit. It was never assessed to tax. So can that HUF go for partial partition? The answer is yes, because 171(9) says, notwithstanding anything contained in the foregoing provisions of this section, where a partial partition has taken place after the 31st day of December 1978 among the members of a Hindu undivided family hitherto assessed as undivided. So it says hitherto assessed as undivided. If the HUF was never assessed to tax, smaller HUFs may be created by making partial partitions, and if required we can have multiple HUFs because of this partial partition. So it applies only to cases which were assessed to tax. If it was not assessed to tax, the provisions of 171 does not apply, so we can take benefit of this partial partition in case of HUFs which were not assessed to tax earlier, and may bring into existence new HUFs as required. This is supported by two decisions also, 166 ITR 776 additional CIT versus Durgamma, 192 ITR 376 Gujarat CIT versus Kantilal Ambala. Friends, I will like to conclude my presentation with one चौपाई of रामचरितमानस और एक सुभाषित. रामचरितमानस में प्रभु श्री राम ने भरत को मार्गदर्शन करते हुए बताया था, मुखिया मुख सो चाहिए, खान पान सब एक, पालई पोसई सकल अंग, तुलसी सहित विवेक. यही बात परिवार के मुखिया पर लागू होती है. ये दिखनी भी चाहिए और होनी भी चाहिए. सही मायने में हिंदू अविभक्त परिवार, हिंदू अनडिवाइडेड फैमिली जो हमारी थाती है, वो केवल टैक्स प्लानिंग के लिए एक टूल मात्र न बने, बल्कि वास्तव में लेटर एंड स्पिरिट में हम उसका अनुपालन करते हुए इस संस्था को हर प्रकार से मजबूत कर सकें, तभी इसकी सार्थकता है. लेकिन आज दुर्भाग्य, चाहे वो NGO हो, चैरिटेबल इंस्टीट्यूशंस हो, चाहे यह HUF की संस्था हो, सबको हमने एक टैक्स प्लानिंग का मोहरा बना दिया, जिसके कारण से जो सही प्रकार से काम करने वाली संस्थाएं हैं, उनके हमें भी अनेक प्रकार की दिक्कतें आती हैं. हम प्रोफेशनल्स की ये ड्यूटी है कि इसको हम यथासंभव रोकने का प्रयास करें. दूसरा एक सुभाषित है, वह भी हमारे हिंदू अविभक्त परिवार के मूल में है, हमारी चिंतन के मूल में है. त्यजेदेकम कुलस्यार्थे ग्रामस्यार्थे कुलम त्यजेत, ग्रामम जनपदस्यार्थे आत्मार्थे पृथ्वीम त्यजेत. अर्थात प्रत्येक व्यक्ति अपने निज का स्वार्थ कुल के स्वार्थ के लिए साथ जोड़ता है, अपने निज के स्वार्थ को छोड़ता है, अपने ग्राम मोहल्ले जनपद उसके लिए अपने कुल की प्राथमिकता को छोड़ता है, और जनपद के लिए ग्राम को छोड़ता है, और अपने सर्वमंगल मांगल्य के लिए, अपनी आत्मा की उन्नति के लिए इस समस्त पृथ्वी को भी छोड़ देता है. इन्हीं के साथ मैं अपने इस प्रेजेंटेशन को यहाँ पर समाप्त करता हूँ. आप सबकी टिप्पणियों की मुझे प्रतीक्षा रहेगी. धन्यवाद. Thank you friends once again.